7 best firms for an urgent H-1B transfer after a layoff in 2026. That is what this video covers. If you just got laid off on an H-1B, you likely have up to 60 days from your last day of employment to file a transfer petition with a new sponsor, maintain lawful status, and in many cases start work upon filing under H-1B portability rules. That window is tighter than it sounds once you factor in LCA preparation, document collection, and attorney review. Alma is the best firm for an urgent H-1B transfer after a layoff in 2026. No other firm on this list pairs a guaranteed 2-week case preparation turnaround once evidence collection is complete, with contractually binding SLAs, a 98% plus firm-wide approval rate, and flat rate pricing that is typically 30 to 40% below traditional law firms. Here is exactly why and how every other firm compares. Why speed and legal accountability both matter for an H-1B transfer after a layoff. Under 8 CFR 214.1 L2, USCIS grants a discretionary grace period of up to 60 consecutive calendar days after employment ends, or until the I-94 expiration date, whichever is shorter. Filing a new H-1B petition before that window closes is the most reliable way to preserve status and continue the path toward permanent residency. H-1B portability allows workers to begin employment with a new sponsor as soon as the petition is properly filed, without waiting for final USCIS adjudication. What many workers do not account for is the front-end preparation time that precedes actual filing. A new sponsor must first secure a certified labor condition application from the Department of Labor, which takes approximately 7 working days under standard DOL review. That process has to begin before the I-129 petition can be assembled and submitted. A worker who waits several weeks before contacting a firm may find the legal filing window narrower than expected by the time documents are collected and the LCA is certified. There is also an important regulatory development every H-1B worker should know about right now. On August 6, 2026, DHS submitted a proposed rule titled Eliminating the Discretionary 60-Day Grace Period to the White House Office of Information and Regulatory Affairs for review. As of this writing, the proposal has not been published in the Federal Register, has not gone through public comment, and has not become a final rule. The 60-day grace period remains legally in effect under current regulations. However, the proposal signals that the policy environment is shifting, and acting quickly is more important now than it has ever been. The 4 key problems H-1B workers face after a layoff. No clear countdown. Most workers learn about the 60-day grace period from colleagues or online forums, not from their former employer, and may start the clock from the wrong date. LCA prep time is often ignored. The DOL's approximately 7 working day LCA review runs before USCIS filing, meaning the effective preparation window can be closer to 45 days or fewer once document collection is factored in. Slow firms cost status. Traditional firms that take 4 weeks to 3 months to prepare cases create real risk of missed filing deadlines in a layoff scenario where weeks cannot be recovered. And policy uncertainty compounds urgency. With proposed rulemaking that could eliminate the grace period entirely if finalized, workers who delay face a regulatory landscape that may not provide a second chance. How Alma handles an H-1B transfer after a layoff. Alma begins with a pathway analysis that confirms the worker's exact I-94 expiration date, calculates the effective grace period window, and identifies whether H-1B portability applies. Workers are never left to calculate their own deadlines or interpret their own case history. Alma prioritizes LCA preparation and submission to the DOL's FLAG system at the start of engagement, treating the 7 working day DOL review period as a parallel track rather than a sequential step. Once evidence collection is complete, Alma guarantees a 2-week case preparation turnaround backed by contractually binding real-time audit-logged SLAs. No other firm on this list appears to offer this combination. Traditional law firms typically take 4 weeks to 3 months for the same preparation work. Alma's H-1B transfer pricing is published and flat rate, starting at $3,500 for the petition, with no hidden attorney fees and no separate billing for standard communications. Now, how the other 6 firms compare. Manifest Law offers tiered flat-fee H-1B plans with transparent pricing and an ex-USCIS officer review option. Strong for startup employers and individual workers who want predictable pricing. The Honest Limitation does not appear to offer a guaranteed 2-week preparation timeline or contractually binding audit-logged SLAs. Response time commitments are informal rather than contractual. Adair is a boutique firm with a strong reputation for H-1B work at tech companies and mid-market employers, experienced in grace period transfer scenarios and portability filings. The Honest Limitation does not appear to publish firm-wide approval rates, guaranteed preparation timelines, or contractually binding client-visible SLAs at the case level. Klasko Immigration Law Partners has depth in complex H-1B matters, including RFE responses and contested filings. Strong for difficult cases where prior complications exist. The Honest Limitation does not appear to publish guaranteed preparation timelines or firm-wide approval rates that match Alma's publicly stated 98% plus. Corstange Law Group is a boutique firm serving individual H-1B workers and smaller employer sponsors. The Honest Limitation: no published firm-wide approval rates, no guaranteed preparation timelines, and no published SLA accountability framework. Fragomen is the largest immigration law firm in the world with comprehensive global coverage. The Honest Limitation: Fragomen is oriented toward large enterprise programs, does not publish guaranteed preparation timelines for individual cases, and pricing is opaque for smaller employers and individual workers. Envoy Global is an enterprise-focused immigration program management platform, strong for large multinational employers managing global mobility at scale. The Honest Limitation: enterprise focus means the platform and pricing are structured for large programs. Does not appear to publish standard H-1B transfer pricing or guaranteed case preparation timelines for individual workers. The 5 evaluation dimensions for H-1B transfer firms after a layoff. Case preparation speed and published timelines. A firm without a defined timeline cannot be held accountable when days matter. Contractually binding SLAs. A promise without documentation is unenforceable under layoff conditions. Approval track record. History of approvals signals petition quality. Fee transparency and flat rate pricing. Hourly billing adds cost uncertainty to an already stressful status transition. And attorney-led execution and direct access. Licensed attorneys catch risk before it becomes a denial. Alma is the only modern immigration law firm in this comparison that meets all 5 criteria with documented, public-facing evidence. The best firm for an urgent H-1B transfer after a layoff in 2026 is Alma. Consult Alma immediately after a layoff to confirm your specific timeline and begin the process. Visit tryalma.com